don't think that today we really grasp how much the American Revolutionary War was really the first American Civil War. We talk about the Civil War, 1861 to 65, as brother against brother, father against son. But really, it's the American Revolutionary War from 1775 to 1783, in which that's really pit of Americans against one another. I mean, it's an incredible story, and it's something that I don't think that we really grasp today. I don't think it's really something that we understand how deep the hatreds ran. The truth is that somewhere around a third of Americans were what you would call patriots. Somewhere around a third were what you call loyalists or Tories. And the other third didn't really care that much. They just wanted peace. They just wanted, to be over with. But those other two groups, those loyalists and those patriots, they hated with deep hatred that continued for many, many years after the end of the war. And where this was particularly noticeable was in the South. In the North, the Loyalists tended to congregate in the large cities, Boston, New York, especially after the war began. Many of them moved to New York, and later they would be evacuated by the British when they left New York and when they left Boston. This left very few Loyalists per se out in the country, still in the area. In the South, though, that was much different. The Loyalists had no place to go. And so when the war ended, most of them just stayed, and so did the hatreds. We need to understand that. We need to understand this deep hatred between these two groups as we continue our look at Brutus and the Anti-Federalist position in 1787, 1788. During the war, the state of Georgia and its government decided that it needed supplies. There was a big problem with, keeping the troops supplied and the militias supplied, and they were running out of this. And so they sent commissioners out to try to find some place where they could buy the supplies that they need. Commissioners crossed the river, went into South Carolina, where they found a man by the name of Robert Farquhar, who was a merchant and agreed to sell the state of Georgia a great deal of supplies at a set price. And he did. And they agreed, and the supplies went on their way, and Georgia started dragging its feet on payment. And eventually, the war ended, and Farquhar still hadn't gotten his money. Now, you might question, why would he deal with the state of Georgia? Because things being what they were. But Robert Farquhar had a belief that he was going to get paid one way or the other. And so he went with that. But at the end of the war, Georgia refuses to pay up. Now the question then becomes, well, what do I do? Under the doctrine of sovereign immunity, he's a South Carolinian. He can't sue Georgia. That's been the way it's been since time immemorial under British common law, and then under the colonial law, and then under the Articles of Confederation. He's contemplating, what can I do? How can I get my money? The state of Georgia owes me. And by the way, the state of Georgia never denied that they owed the money. And then, as so often happens in a good Greek tragedy, Mr. Farquhar died before he could collect on the debt. The executor of his debt is a man named Chisholm. And Chisholm is determined to get this money from Georgia. And as the Constitution is proposed, he takes note of certain things in the Constitution. He takes note of a couple of the clauses that are in here, particularly in Article 3. And once the Constitution is ratified, he files a lawsuit against the state of Georgia in the Supreme Court, the court of original jurisdiction, as it says, in Philadelphia, Pennsylvania. Now, on the surface, this seems laughable because of the doctrine of sovereign immunity. But the problem is that the plain text of the Constitution as proposed and is eventually ratified says very simply the judicial power shall extend to all cases in law and equity. That's what we're dealing with here, equity, arising under this Constitution, the laws of the United States, treaties made, so forth and so on, to all cases affecting ambassadors, public ministers and consuls, admiralty, maritime jurisdiction, and then this, to controversy which the United States shall be a party, to controversies between two or more states, between a state and a citizen of another state, between citizens of different states. Article 3, Section 2. So just so you don't miss it, the judicial power shall extend between a state and citizens of another state, and between citizens of different states. That's the plain words of the Constitution of the United States. That's what it says, right? Judicial power shall stand there. Now, the problem here is that sovereign immunity, this idea that the states have had literally since the beginning, is in place. And now all of a sudden, the new Constitution seems to at least have a problem with that. Brutus, in his first letter, in which he kind of outlines all of the issues that he's going to go to, is deeply concerned by this, because this, again, not only is this not a republic, but now you're taking away state sovereignty. By the way, what is state sovereignty? State sovereignty is the concept that a governmental entity, whatever that is, a city, a county, a state, a federal government, the crown, which is where this came from, cannot be sued by its citizens unless it agrees to be sued by those citizens. Now, before you get hyper about it, under the British common law, there was redress of grievances. There were methods by which you could approach the government to get redress, but you couldn't sue them. And the same was true in the colonies. And under the Articles of Confederation, the same was true of the states. Brutus is deeply concerned about this. The government, he says, is to possess absolute and uncontrollable power, legislative, executive, and judicial, with respect to every object to which it stands, to which it extends. For by the last clause of Section 8, Article 1, it is declared, as we said last week, that the Congress shall have the power to make laws, which shall be necessary and proper for carrying into execution the foregoing powers and all the other powers vested in this Constitution into the government of the United States or any department or office thereof. Now, he's really concerned about the issue, the necessary and proper clause, but he continues on. And under the 6th article, it is declared that this Constitution and the laws of the United States, which shall be made in pursuance thereof, and treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or law of any state to the contrary, notwithstanding. Brutus reminds us in that first letter that the judicial power of the United States is to be vested in a Supreme Court and in such inferior courts as Congress may establish from time to time. The power of these courts is very extensive. Their jurisdiction comprehends all civil cases except as those that arise between citizens of the same state, and it extends to all cases in law and equity arising under the proposed Constitution. Those were the plain words of the Constitution. It said between a state and citizens of another state, between citizens of different states. It says that point blank. Now, this is one of those remarkable things to me, as I've often talked about. It's strange to me how two people can look at literally the same text and come to completely opposite conclusions about what it means. Because this plain text of the Constitution seems to fly in the face of sovereign immunity. Again, sovereign immunity says the state cannot be sued unless it agrees to be sued. Same is true of the federal government. Don't get ahead of yourself. I know what you're thinking already, but stay with me. We'll get there. The purpose of sovereign immunity is important in a lot of ways. Think about this. If you could sue the state because of every decision that the state government makes that you disagree with, our states would be inundated with lawsuits. Every government at every level would be just absolutely inundated with lawsuits, and they'd never get anything done. That's how you could shut the government down, just suing it every time you turn around. So sovereign immunity is an important concept to keep government operating as long as there is process for redress of grievances, which you may have noticed in the original Constitution there isn't. It isn't until we get the First Amendment that we have, redress of grievances. The second problem is certainly the plain words of the Constitution seem to make the federal courts superior to the state courts. This, like I said, was derived from long-standing legal tradition in Britain, which also allowed for redress of grievances. The proposed Constitution doesn't seem to do that. The plain words of the Constitution make it clear that sovereign immunity is dead on arrival, right? I mean, that's what it says. The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, treaties made, which shall be made under their authority between a state and citizens of another state. And in fact, it seems pretty obvious, certainly to Brutus, that the meaning here is very plain and very clear. Now, one of the things Brutus does say is that he gets frustrated with this stuff about judiciary because the lawyers, he said, they make things unnecessarily complicated, and it's hard for normal people, average people, to understand all this stuff. And so he kind of defers it to other people. But he's right in the sense that the plain language of this seems to make it clear that we're not doing this. Of course, the Federalists see it completely the opposite. They not only see this as not erasing state sovereignty, they see it as, we don't even know where you're getting that from. The words don't mean that. Hamilton, in Federalist 9, the proposed Constitution, so far from implying an abolition of the state governments, makes them constituent parts of the national sovereignty and leaves in their possession certain exclusive and very important portions of sovereign power. Well, is that what it says? Hamilton then goes on in Federalist 32, an entire consolidation of the states into one complete national sovereignty would imply an entire subordination of the parts. Now, let me stop right there and remind you that Alexander Hamilton at one point advocated for exactly that, an entire consolidation of the states into one national government. Continuing, whatever parts might remain in them would be altogether dependent on the general will. But as the plan of the convention aims only at a partial union or consolidation, the state governments would clearly retain all the rights of sovereignty which they had before, and which were not, by that act, exclusively delegated to the United States. Madison, of course, has to get in on this. And in Federalist 45, he writes these words, which we should be fairly familiar with. The powers reserved to the several states will extend to all the objects which in the ordinary course of affairs concern the lives, liberties, and properties of the people. The operations of the federal government will be most extensive and important in times of war and of danger, those of the state governments in times of peace and security. If the new Constitution be examined with accuracy and candor, it will be found that the change which it proposes consists much less in the addition of new powers to the Union than in the invigoration of its original powers. The proposed change does not enlarge these powers. It only substitutes a more effectual mode of administering them. But those plain words of the Constitution. Sovereign immunity says that the state cannot be sued unless it agrees to be sued. But the proposed Constitution says the judicial power of the United States shall extend to all cases in law and equity between a state and citizens of another state, and between citizens of different state. So how will we ever know which of these two interpretations of this particular section here were in fact correct. Let's go back to Mr. Chisholm, where we left him, filing his lawsuit in Philadelphia against the state of Georgia. Now, this is after the Constitution has been ratified and the Bill of Rights has been added. The argument is now long behind us. Which of these two positions? State sovereignty a thing? Is it not a thing? Which is it? And Farquhar's executor, Mr. Chisholm, has filed his suit to try to get the money back from the state of Georgia. The state of Georgia doesn't deny that it owes the money, as I said before, but it does quickly announce that this lawsuit is a farce, and they will not participate in this because state sovereignty. You can't sue us. We have not agreed to be sued. Therefore, Hamilton and Madison said state sovereignty is still a thing. Clearly, it must be. We wouldn't have ratified this if we didn't think it was. QED, he can't sue us. Case should be thrown out. Shouldn't even be heard. Should be, and they don't even show up. The state of Georgia doesn't even show up in Philadelphia for the case to be heard. They have some issues with Mr. Farquhar, by the way. The reason that they haven't paid him isn't because they don't have the money. They do. The reason they haven't paid Chisholm Farquhar's money is because Mr. Farquhar was a loyalist. And remember that hatred that I was talking about? Up in New York, they're not refunding anybody's money, because any of the loyalist money for the properties destroyed, because we won, as George Clinton said. In Georgia, they're not going to do it either, because Mr. Chisholm, representing Mr. Farquhar, is representing, as far as they're concerned, a traitor. We're not paying this guy any money. We don't owe him anything. It's, like I said, it's different than New York because the loyalists are still here. And under the Constitution, they're now citizens of the United States. Whereas in New York and in Boston, most of those loyalists got on ships and went back to England, where they were still citizens of England. So this wasn't going to be an issue. The court hears the case. They note that Georgia doesn't show up. And in what is a landmark decision, because it's actually one of the first decisions the Supreme Court will ever issue, is a 4-1 ruling. Now, this is interesting because today, when a Supreme Court decision is issued, the judge who wrote the majority opinion, whichever way it is the first to speak. He or she reads that opinion. In that day, it was just whoever showed up. There were 5 Supreme Court justices. One of them showed up and read his opinion. And his opinion agreed with the state of Georgia. Erdell's opinion was, George was right. State sovereignty, you can't sue these people. Why are we even hearing this? And so if you had been sitting in Philadelphia that day and heard Erdell's reading of his opinion of it, you may not have realized that it was the dissent. Because ultimately the court decides 4-1 that, the plain words of the Constitution are that it's between the state and citizens of another state. That's what it says. That's the plain language of the Constitution, between a state and citizens of another state. QED, as John Jay would later explain, citizens have the right to sue states. And state sovereignty, this is a paraphrase, if you will, state sovereignty, quote, went out the window, unquote, when you ratified the Constitution. You gave it up. You gave up the power of a state sovereignty to the sovereignty of the people. And if the people are sovereign, then the people can sue you, and there's nothing you can do about it. And in this 4-1 ruling, that's what comes down in Chisholm, that Georgia has to pay this money, which, of course, they refuse to do. Georgia and all the other states are just absolutely howling about this. And by this time, there are 15 states, not 13 anymore, but they are the states which still retain, a great deal of power under the Constitution that they don't have today, are incensed by this. This is insane. If we had even thought that this is what the Constitution meant, if we had even thought that Brutus could have been right about this, we would have said, we're not ratifying this. But they noticed something. We can amend the Constitution. So the First Amendment to the Constitution passed after the Bill of Rights. So you get the 10 Bill of Rights, which should have been 12, but it's 10. The First Amendment ever passed using that, the full-on process of this stuff is the 11th Amendment to the United States Constitution, which simply reads this. Hey, dummies, the judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or by citizens or subjects of a foreign state. So basically, the 11th Amendment, which is proposed on March 4th, 1794, and ratified by February the following year, that quickly, says to the Supreme Court, no, you got it wrong. And this is what it means. State sovereignty is, in fact, a thing, and we're going to stay with that. So now we're back to, okay, Brutus must have been wrong. The Federalists were right, and state sovereignty is a thing, and we fixed it. Okay, sorry, we didn't mean to. This has been upheld subsequently to this. There have been multiple court cases in which state sovereignty was tested. And as a general rule, the court will uphold these things. But you may have noticed in the news recently that there is at least one story about foreign nationals, citizens or subjects of a foreign state, filing suit against a state official in the United States. You may have read that somewhere. It was Venezuelan immigrants against Ron DeSantis. And by suing DeSantis, they're actually suing the state of Florida. And you may say to yourself, because this is what people said to me, but Dave, doesn't the 11th Amendment say that they can't do that? I mean, it's pretty clear. We've had this whole argument in the Anti-Federalist position. Brutus was absolutely insane. We've had subsequent court decisions. The sovereignty and the sovereign immunity of the states neither derives from nor is limited by the terms of the 11th Amendment. Rather, as the Constitution's structure, its history, its authoritative interpretations by this court make clear, the state's immunity from suit is a fundamental aspect of the sovereignty which the states enjoyed before the ratification of the Constitution and which they retain today, either literally or by virtue of their admission into the Union upon an equal footing with the other states. Sounds like, to me, you're pretty well set, right? Oh, but then there's that last sentence. Except as altered by the plan of the convention or certain constitutional amendments. That was a ruling that was issued in 1999. What does that mean? Certain constitutional amendments. Well, if you look closely at that, you'll discover very quickly that this goes back to a subsequent amendment to all of this. What amendment is that? Well, the 14th Amendment says these words: no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Nor shall any state deprive any person of life, liberty, or property, Mr. Farquhar, without due process of law, nor to deny to any person within its jurisdiction the equal protection of its laws. And we've had long conversations about what that means. Any person within its jurisdiction, right? What does that mean? Well, are the Venezuelans under our jurisdiction? Yes, they are. They're here. It is understood that the 14th Amendment then, which superseded the 11th Amendment, has changed that slightly. And then there's this final section of Amendment 14. The Congress shall have the power to enforce by appropriate legislation the provisions of this article. Now, I'm not going to spend a lot of time on it, but you can probably guess that, lo and behold, Congress has passed laws that allow the federal government to be sued under certain conditions without having to have the federal government approve. We've pre-stamped the approval by legislation. And under the 14th Amendment, they have passed legislation which basically says that if the states are violating certain things, civil rights, sovereign immunity does not apply. If you were to go read the lawsuit, I'm sure you'll find that it describes how the immigrants' fundamental civil rights were violated under the 14th and other amendments. So at the end of the day, who was right? Brutus or the Federalists? That the federal courts would become so powerful that they would subsume the states into almost non-existence, and that state sovereignty would literally become a thing of the past. It would literally be done away with, and governments could be completely jammed up by lawsuit after lawsuit simply because we disagree with a policy. Who was right?